All right, so now we're going to talk about everybody's favorite stuff, which is the laws. Yay, laws. I know you may not be able to see it off of our screen here, so I'll put it up on your screen. Um, but yeah, laws. In my opinion, probably the most important part of this video. Mostly because this is the stuff that could potentially land you in jail if you get it incorrect. So, very, very important that you do follow through. The place where you're going to find this is the LexisNexis.com. LexisNexis.com/hot topic/Colorado. If your browser comes up with an error, you just have to add the www to that. You can also find these laws at the Colorado legislature at their website. I just find it a lot easier to navigate the LexisNexis. The LexisNexis is an official source for these laws. So we're going to show it to you from the LexisNexis. Always verify this information. We're showing it to you straight from the source, but nothing like verifying it yourself. One of the things that we've become really, really good at is just sharing incorrect information. That's the last thing you want to do. Verify it. I know I'm not lying to you. I know Isaac's not lying to you. We've got attorneys that advise us and counsel us about the laws. I've been doing this shit almost 10 years. I know this stuff almost word for word. Isaac knows this stuff, but you don't know that stuff. You don't know that we know that stuff. Verify that information every single time. There's one thing that I want to talk about before I'll skip that. I'll leave it for the class.
I want to add one thing real quick. One of the things that you'll find in here when you read this for yourself, because you should read this for yourself, it's my favorite part of the entire Colorado Revised Statute for concealed carry handguns. We're not legally responsible for what we tell you. So I like to tell people that because that's in the law. I'm not legally responsible for what we're about to tell you. You're responsible. You can't go in front of the judge after you just shot somebody in the face and say, well, the firearms instructor said it's not going to work. You are responsible for knowing this stuff. So pay attention, watch this part, but please go and read this for yourself at least twice.
Yeah, absolutely. 3-4 times if you're ESL like myself. If you don't know what that is, that's English as a second language. But anyways, let's start off with 1812-201. And basically what 1812-201 explains is why this law was created. 1812-201 is the legislative declaration. And it basically talks about inconsistencies. There's inconsistencies across the board. Before we became a shall issue state, we were what's known as a may issue state, which meant that every jurisdiction had their own laws, rules, regulations in regards to concealed handguns. We became shall issue state in the early 2000s, which means that if you meet these state requirements to obtain your concealed handgun permit, your jurisdiction has to issue you that permit. They don't get to say what the curriculum has to be, even though there's a particular sheriff who may think that. They don't decide what the curriculum is. They don't decide what the time requirement is. They don't decide any of that stuff. That's stuff that we're going to talk about right now. But anyways, that's what 1812-201 is all about. If we go down to the bottom to subsection 3, the second sentence of this says the General Assembly does not delegate to the sheriffs the authority to regulate or restrict the issuance of permits provided for in this Part 2 beyond the provisions of this Part 2, an action or rule that encumbers the permit process by placing burdens on the applicant beyond the sort statements and specified documents detailed in this Part 2, or that creates restrictions beyond those specified in this Part 2 is in conflict with this with the intent of this Part 2, and it is prohibited. Again, just to reiterate, sheriff's offices, all they really do is process your application. They don't make the rules, the laws. Very important information for you to know as a student, not just because we're going through some stuff. Other instructors have gone through some stuff. We've seen students been illegally denied or rejected. Very important for you to know this stuff, because really the first line of defense is yourself. If you show up to a sheriff's office and they don't understand what this stuff is, it's up to you to kind of educate them. You try and be as polite as you possibly can, but you may have to educate your sheriff's office on what these laws are all about.
Yeah, so just to reiterate, what this means is the sheriff's office can't add anything to this process. They can't add anything that they want you to do or they ask you to do. They are bound by this law as much as you are.
Yeah. And then if we move it along to 1812-202, we start talking about definitions. And two definitions that I want to discuss, and maybe Isaac wants to discuss other ones, but I want to discuss 1812-202, subsection 2. That's what a certified instructor, what the definition of that is. And the reason I like to talk about this stuff is because there's a lot of sheriff's office who believe that you have to be an NRA certified instructor in order to teach these classes. Now, Isaac and myself, we are NRA certified instructors, so this really doesn't affect us. But there's other instructors out there who are certified through another organization who are amazing instructors. These people have really good, solid content. They have really solid advice, amazing instructors, but unfortunately, some sheriffs don't understand what the laws are, and because they're not NRA certified instructors, they're rejecting them. Now, here's what a certified instructor means. Now, you could talk about a county, municipal, state, that's law enforcement. Instructors don't fall under that. Peace officer standards and training, we don't fall under that. Federal military agency, your run-of-the-mill instructor, your everyday instructor is going to fall under 1812-202-2D. A national nonprofit organization that certifies farms instructors, operates national farms competitions, and provides training, including courses in small arms safety, use, and marksmanship. Nowhere on there does it say a particular organization. It just says the organization has to be a national nonprofit organization that deals with this stuff right here. There's other organizations outside of the NRA. The other thing that's happening right now, I don't know if you've been paying attention to current events, but there is a small chance, however small that may be, there is a small chance that the NRA will be dissolved. They have been sued for, we'll just leave it at that, I guess. So tiny chance that may go away. And people have asked me, like, what happens if there's no more NRA certified instructors? How do you do classes? Well, in the state of Colorado, you do not have to be an NRA certified instructor. So there are other alternatives. And then handgun training class. In the state of Colorado, it's pretty straightforward. Guns for Everyone falls under two sections. We fall under two categories. 1812-202, subsection 5A, paragraph 2 or Roman numeral 2. It says a firearm safety course offered by a law enforcement agency, which we're not, an institution of higher education, which we're not, but then it says, or a public or private institution or organization or firearms training school that is open to the general public and is taught by a certified instructor. We are that. That last portion of it, we are. So we fall under that section there. And if you notice, there's nothing in the CRS that says our class has to be 4 hours long, 6 hours long, 2 hours long, 1 hour long. There's no time requirement. There's also nothing in here that says we have to follow a certain curriculum. Every instructor is creating their own curriculum, whatever they feel is necessary for their students. I appreciate it because it allows me to adapt to whatever circumstance we're in. Right now is a perfect example of the COVID situation. We can adapt to that. There's some students who need more help than others with the safety stuff. This allows me to spend more time with them talking about safety, or there's some students that don't know anything about the law, so it allows me to pay a little bit more attention with them. I actually appreciate not having a strict curriculum to follow because it doesn't allow you to adapt. And then we've got Roman numeral 3, which says a firearm safety course or class that is offered and taught by a certified instructor. 3B says, notwithstanding paragraph A of the subsection 5, handgun training class does not include any firearm safety course that allows a person to complete the entire course via the internet or an electronic device or in any location other than the physical location where the certified instructor offers the course. So what we're doing in this particular context, we are providing a portion of it via the internet or electronic device, but not the entire portion. So that means you still legally would have to show up in person, attend that in-person portion, which is going to be about 45 minutes long, sometimes a little bit longer. And I'm sure if we have one student, it's probably not going to take 45 minutes, but about 45 minutes, you have to show up for that portion. But yeah, that's the definition for that. In either case, whether it be 1812-202, 5A, Roman numeral 2 or 3, there's no curriculum that we're bound by. There's no time requirement that we're bound by. You as a student legally don't have to go shooting. We offer it as part of our course, but it's an optional portion of it. We feel that you're an adult and you can make a decision for yourself. So that's what that is. Anything you want to?
No, I don't have anything to add for that.
Pretty straightforward. I mean, you've got to be a really dense individual to
To struggle to understand this.
I couldn't imagine somebody so dense that they couldn't understand how basic this is.
So while he's getting to the next section, something that we always say in our classes is when you're reviewing this stuff or when you're telling other people, a lot of times you'll hear people say, well, my friend's a cop or my brother-in-law's a cop, and he said, we don't really care what other people say. If you can verify it here in the law, then it stands. If it's not in here, then it doesn't exist. A lot of people will get laws confused from one state to the next state. They say, well, in Texas, I can do that. Well, we're not Texas. We're better than Texas. Right. We have different laws than Texas does. And so don't take people's word for this, even if they're a police officer. Correct. The only person's word I will ever take for this is an attorney. And even then, correct, I'm going to be careful about it.
Correct.
All right, moving on.
So I'm going to skip the criteria to obtain a concealed handgun, which is 1812-203. That's something that we can discuss if you really wanted to in person. But essentially the criteria is you have to be 21 years of age, you have to be a legal resident of the state of Colorado, and then haven't taken a class. If you've been in the military, your DD-214 might be valid for that. I want to talk about your specific situation in person, or you can call us in emails and see if your DD-214 will qualify. But I think in the interest of time, those are kind of the general three. Is you have to be 21 years of age. We'll talk about denials and stuff here in a little bit with the application process, but that's the criteria. 21 years of age, legal resident of the state of Colorado, and then have a training certificate from a certified instructor, or again, there's other means of proving that you can be a competitive shooter. DD-214s work as well. Active orders will work as well, obviously. So there's other ways of doing it. So
I want to add something just because I normally teach in Colorado Springs. We get a lot of soldiers who are not necessarily residents of Colorado. If you're a soldier and you're stationed here in the state of Colorado and you have orders that you're supposed to be here, that is your proof of residency of Colorado, or of being a resident of Colorado. And so that will work as your proof of residency. The other thing I want to mention is marijuana, because we get this question a lot. If you have specific questions about this, we'll answer them. Generally speaking, the restriction is you can't be a user of any illegal substances under state and federal laws. So just because Colorado has legal weed does not mean you can get your permit if you're a user of marijuana. If you have specific questions about that, please ask them in the class.
Yeah. This 1812-204, one of the things that I want to talk about here, it starts off by talking about you having to keep your permit with you. If you're going to carry a gun and you have a permit, you have to keep it on you. It's kind of like your driver's license. If you're driving, you have to have your driver's license on you. You could potentially get a ticket for not having the physical card with you. And if you do, it's one of those things you show up to court and it shall be dismissed. One important thing that I do like to talk about in 1812-204 is subsection 3. It says that a person who may lawfully possess a handgun may carry a handgun under the following circumstances without obtaining a permit, and the handgun shall not be considered concealed. The handgun is in the possession of a person who's in a private automobile, some other private means of conveyance, and who carries a handgun for legal use, including self-defense, or the handgun is in the possession of a person who is legally engaged in hunting activities within the state of Colorado. So I like to break this down really quick. Disregard the fact that I just read that shit word for word without looking at this shit. It says a person who may lawfully possess a handgun. One of the things words matter when it comes to the law. It doesn't say a permittee. It says a person who may lawfully possess a handgun. In the state of Colorado, if you go back to 1812 Part 1, read it. I encourage you to read Part 1. We're in Part 2 at this moment. Read Part 1. It talks about an 18-year-old being able to possess a firearm legally. They can't buy one. You don't have to buy something to own something. I'm married. I know that very well. So that joke's better in class, by the way. So you don't have to buy something to own something. A gun could be gifted to you as an 18-year-old. So even at 18 years of age, it's important for you to understand this. A lot of college students are on their own now and afraid of the circumstances, or let's be honest, colleges don't always have the best of reputations for keeping their hands to themselves and that type of stuff. So as soon as you turn 18 years of age, this applies to you. You may carry the handgun without obtaining a permit. And the handgun shall not be considered concealed. The other thing is, this law says, and who carries the handgun is in the possession of a person who's in a private automobile. Doesn't say your private automobile, it says in a private automobile. So Isaac's car is a private automobile, so I would be able to carry there without a permit. My company vehicle, it's not owned by a private individual, but it's still potentially owned by a private company. It is private. I know a lot of people would ask about the RTD. Well, obviously that's not a private vehicle. So we're talking about private means of conveyance. Private means of conveyance. The rule of thumb there is if you can get a DUI in it, it would be your private means of conveyance. Your bicycle, horse riding, lawnmower, tractor, that type of stuff, that's where the private means of conveyance is. One important thing to note is, for whatever weird reason, there is a separate law that talks about snowmobiles. For whatever weird reason, that's separate, but only that. ATVs, you're cool, but you put on a track on that bitch and call it a snowmobile, and all of a sudden, for whatever weird reason, there's a specific law about snowmobiles. I encourage you to look it up. We won't talk about that right now. But yeah, as soon as you turn 18 years of age, you can possess that handgun in your vehicle without a permit, private means of conveyance, private automobile if you're hunting in the state of Colorado.
So there's two more circumstances where you can carry a handgun that you do not need a permit, and it's pretty obvious, but it deserves to be said, and it's not listed here. It's listed in 1812 Part 1, which is if you're in your residence or your dwelling, you can carry a handgun. You do not need a permit to do that. And the other one is if in your place of business. But it has to be your place of business. It can't just be, I work at Walmart, so I'm going to carry a gun without a permit. It has to be your place of business. So just to summarize what we just said, 4 circumstances where you can carry a loaded, concealed handgun, and it shall not be considered concealed. Or you can otherwise carry there. In your home, in your personal business, your personal private means of conveyance, or private automobile, or while you're actively hunting. And actively hunting means you have to be hunting. You can't just put on a orange vest and walk down Colfax and say you're hunting. You've got to be in season with a tag, in the right zone, all of that stuff.
Yeah. So let's talk about the application procedure, background checks and all that stuff. And this kind of outlines a little bit of what you have to show up. You have to, full name, date of birth, address, all that stuff. I won't bore you with that stuff. Once you fill out the application, it says, and if you do fill it out online, most of you, because of the COVID, most of this is going to be done online anyways, but there are some counties that are doing it in person. But if you're one of those that if you're in a county that's doing it online and then you have to show up in person, do not sign it. This is something that the signature has to be witnessed by the whoever the individual is there at the sheriff's office, who's ever receiving that. So anyways, you're going to apply to the sheriff where you reside or own a business in, or even if you maintain a second residence. So a lot of college students that are staying here in state, you may be staying part-time at your dorm room up at CU or CSU or UNC, whatever it might be. Well, that's your second residence. That's your second residence. And then if you're staying with parents or whatever it might be. So it does say second residence, or if you lease or own real property used by the applicant in a business. So where you reside, have a second residence. still reside or own a business in. This one right here, own a business in, we've actually personally have had issues with counties not understanding what that means. I won't mention the county for whatever. We got it all figured out, but it was a moment where we had to educate that particular county on what the laws actually were. So this is why it's so important for you to understand these laws, because you might have to educate them. You try and be as polite as possible, but sometimes they need some education on what the laws actually are. So if you own a business there or you live there, you can apply there. They're going to charge you two fees. The first fee is their own processing fee, which shall not exceed $100. And then the second fee is currently $52.50, and that's the state fee, the CBI fee. So unfortunately, for your freedom to defend yourself, you might be paying up to $152.50. Every county is slightly different, although they have to follow the same laws. The way they administer the process can be different. So when things were normal, Jefferson County was Monday through Fridays, walk-ins only. Denver was Tuesday through Friday, walk-ins only. Some take checks, some don't. Some take money orders. Some take certified funds only, which is weird because cash you would think was certified funds, but somehow it's not certified funds. Some only take credit cards, that type of stuff.
So all the information, because we're kind of generalizing a lot of this stuff, the information specific to your county you can find on your county sheriff's website. They will have it organized and presented in a way that you can understand, and it will lay all this out. We're kind of walking through the guidelines here, but you do have to follow what your county says. So they'll tell you how they take payment, how they handle the application itself, whether they're under COVID modified rules right now, when you can get your appointment, all of that stuff. And your application will be available on your county sheriff's website.
Yeah. And most of these counties are on COVID modified rules, which is ironic. Very ironic. So yeah, it's very important that you go to these websites. Remember, I know I'm saying a lot of stuff, but it's important that you don't get confused. The only thing they really have a say about is how they administer the process. They don't make the rules about what your requirements are, your curriculum, your time, all of that stuff. Really, the only say they have is whether they're going to be open Monday through Friday, how they're going to accept payment, that type of stuff, how they administer the process. So anything else you want to add about this stuff right here?
We tell everybody, read the law, read the law, read the law. This part is probably not the most important because you can get the information you really need from the sheriff's website. But if you encounter a problem, that's definitely where you want to head to.
Yeah, it's kind of a standard government application process. Is you're going to present the typical stuff. So let's talk about what happens once you submit your application. So once you submit your application, we're going to look at 1812-206. Once you submit your application, it says that they have legally 90 days. Now it says 90 days. It doesn't say business days. It says days. Words matter. There is a certain portions here where we'll talk about 3 business days, that type of stuff. Words absolutely matter. They have 90 calendar days to either approve or deny your permit. Here's one thing that's super important right now during COVID. If you're watching this video past COVID, one, we're lazy as shit for not updating that video, but obviously it wouldn't apply at that moment. But especially during these panic moments during COVID, they're behind. I mean, like Isaac mentioned previously, close to 5 million people, if not more. That's kind of just a ballpark. New gun owners. Kind of the same amount are applying for concealed handgun permits. It's an insane amount of people that are applying for these permits. I know in Adams County, as of right now, today's the 28th of August. As of right now, if you go to Adams County and try and make an appointment, you won't get in there until mid-December or so. So that's taking 4 months. This law, although frustrating, says that it's from the time that they receive all of that information. Not when you make an appointment, not when you call them, not when they set your appointment. Until they receive all that information, the clock's not ticking. Once they receive all of that information, it's 90 calendar days. Very important for me to bring that up. I get a lot of angry emails from students who say, oh, this is bullshit. I agree with you, but if in fairness, if we're asking them to follow the laws, and I mean, unfortunately, I may not agree with this, but that is what the law says. Once they receive the documents, then that's when you can go apply. I'm sorry, that's when the 90 days start ticking.
So why don't you talk about what happens after 90 days?
So after the 90 calendar days, if you still haven't received an answer, you have every right, according to the law, to go in there and request a decision. They may deny you, but that denial at least is an answer, and they still have to continue the process. If they figure out, no, you should have got the permit, then they'll issue your permit, or vice versa. They couldn't approve you. They could approve you just to give you an answer, but they still have time after that to continue their background process. And if they find out that you shouldn't have had the permit, then they can take it back away. But yeah, day 91, according to the law, you have the right to go in there and request a decision. It might be the decision. It may not be the decision you want, but you do have the right to request that decision. One thing that I want to talk about in 1812-206, unless you've got stuff to say.
Nope.
So, in the state of Colorado, you're not legally required to notify an officer that you have a firearm on you. We can get complex with this, but in the interest of keeping this very brief, there's nothing in the law. The law does not exist that says that you are obligated under law. This is not an opinion. This is not what I'm telling you to do, telling you not to do. Again, not an opinion. We can talk about opinions in class if you wanted to. But there's nothing on here that requires you to notify an officer about your firearm, not about your permit, not about anything like that. The reason I bring this up now is right here in this law, in 1812-206, subsection 3, C, it says, except for suspected violations of section 1812-105 and 1812-105.5, and if you read the laws, it's essentially carrying a concealed handgun without a permit. A peace officer, so let me start that again, except for suspected violations of section 1812-105 and 1812-105.5, a peace officer may not use or search a database of permittees maintained by a law enforcement agency to establish reasonable suspicion for a traffic stop, or when contacting an individual to justify probable cause for search or seizure of a person or person's vehicle or property. Very important for you to understand that they cannot use your permit, they cannot search that database to create that probable cause. Now, I've made this mistake in the past, and I think it's important for you to understand this. Creating reasonable suspicion and probable cause are two different things. So it's not the same. Reasonable suspicion is one thing, probable cause is a completely different thing. I encourage you to look at your rights, your Second Amendment, look at Terry stops, Terry versus Ohio, that type of stuff. But in the state of Colorado, 1812-206 subsection 3, paragraph C, does not allow them to access that database to create probable cause. Again, reasonable suspicion and probable cause, two different things.
So I want to say a couple things real quick, because we're starting to get into the area of talking to cops. And you can have this argument on the side of the road with a police officer if you want to, but it will almost always not go your way. Yes, you should know your rights, and it's okay to assert what you know. But if you want to get into an argument with a police officer, it's my own personal recommendation that you do that with a lawyer next to you in a arbitration or a courtroom setting or something like that. Do not get physical with a cop over something like this. That's stupid.
And if you do really want to fight it, I mean, just take the L, go to jail. Because there's some of you are like, no, I'm not going to tell them anything. Like, fantastic, just go to jail, bond out, whatever. We're saying the same thing.
Yeah.
So yeah, absolutely.
The other thing I want to point out about this, because I don't know if you cover this normally, and since we're here, each county is required to keep a list of all current permittees in their county. They're also not allowed to share that list with other counties unless there is a court order to do so.
That's at the beginning of this.
So you could have a cop who can look up whether or not you have a permit in the county where you're at, but they don't have access to every county across the state. So understand that. They're not supposed to look up your permit just for fun. They're not supposed to do that, but they may or they may not do that. But it's important to know how these records are kept. Yes, there is a record of you having a permit with the county where the permit was issued. No, not every cop has that information.
Yeah. It's not an automatic thing. Yeah, absolutely. So let's move it along. Very important to kind of reiterate is right now we're in a time where if you do want to fight a cop, it's done so in court. Gotta emphasize that one more time as we're stalling for time here. I'm not going to go cover 207 because that talks about them taking away your permit, stuff like that. And it's basically the same as the denials. You're going to get denied for really all of the standard stuff. Are you a wife beater? Are you a felon? Are you a pothead? Are you a drunk? That type of stuff. These are the type of stuff that I want to talk about in person because there's a lot of circumstances that there's no absolute here. I know friends, I know people personally who have spent time in prison for multiple felonies who legally own guns and legally have their concealed handgun permit. So that's why, for me, it's important to talk about denials and that type of stuff for your specific thing. But it really is a general thing. If you have an active red card, if you're a medical pothead, you're probably going to be denied. If you're a recreational pothead, though, it gets treated a little bit different. See, these are all these little nuances that we need to talk about. I feel that we should talk about in person, unless you want to talk about that type of stuff right now.
The only thing that you didn't mention was active restraining orders.
Yeah.
So if you have an active restraining order against you, you're not going to be able to get your concealed permit.
Committed to a mental institution against your will, that type of stuff. So a lot of it is just standard stuff. I do want to talk about issuance of temporary emergency permits. These kind of became popular towards the beginning of COVID because ironically we had a governor who we thought was going to go completely left with these, and he said, no, not only can gun stores stay open, but I am instructing sheriff's office to start issuing, without a class, by the way, without a class, temporary emergency permits, without having to show up in person. Basically just do a simple online application and obtain a temporary emergency permit. That was one of his executive orders, whether you believe it or not. And basically, under normal circumstances, an emergency permit is really just reserved for people who have active restraining orders against somebody else, not against them, but against somebody else. Those type of situations where it would require like an emergency thing. Very important for you to read this 1812 209, 1812 209. It's cheaper for you to get your permit. I don't want to go in depth with this. It's cheaper to get your permit. You can be 18 to get this permit. So if you're an 18-year-old that has a restraining order against an ex-boyfriend or whatever the case may be, you can now get a temporary emergency permit. You don't have to wait until you're 21. It's usually valid for a period of 90 days. So it's not going to be a permanent one, but it's cheaper, faster to get. And again, if you're somebody who's not yet 21 and you got somebody crazy, a stalker, that type of stuff, you can obtain this temporary emergency permit as well.
As far as COVID goes, up and down, things are changing all the time. That's an important reason why we need to talk about this right now, because for most people, this is not going to apply right on August 28th. But who knows in the fall, or who knows in the spring, if things change again, temporary emergency permits could become more relevant.
So let's talk about maintenance of permits. And if you have questions, if you're sitting there like, what the hell what need clarification? That's what the in-class portion is going to be all about. Where we're going to do some additional stuff in the in-person portion, but that's also a good time to ask all of those questions in the in-person portion. 1812-210, if you move, you have 30 days. Within 30 days of a permittee changes the address specified on his or her permit, or within 3 business days. Remember, I told you words matter. Notice how here they specifically said 3 business days, but here they only said 30 days. Calendar days versus business days. So or within 3 business days after his or her permit is lost, stolen, or destroyed, a permittee shall notify the issuing sheriff of the change of address or permit loss, theft, or destruction. Failure to notify the issuing sheriff pursuant to the subsection 1 is a class 1 petty offense. So you've got 30 calendar days to notify the issuing sheriff that you have moved. That doesn't matter if you move across the hall from your current address or if you move across the state. Regardless, the law says you would have to notify the issuing sheriff. Now, when you renew your permit, which we'll talk about here in a little bit, then you would renew with the new sheriff. But if it's a simple address change, you've got 30 calendar days and it's free. You don't have to pay anything. But if your permit is lost, stolen, or destroyed, you have 3 business days to let them know that from the time that you found out that it was lost. And that they will charge you $15 for, if I'm not mistaken.
Yeah, $15.
$15. Yeah.
And it does say that if your permit is lost, stolen, or destroyed, it is automatically invalid. So it's on you to get that taken care of quickly, because the moment you no longer possess that permit card, it's no longer valid. You don't have a concealed carry permit until you resolve the issue.
Yeah. And if it's an address change, then it's still valid. It would still be valid. And the class 1 petty offense, I got to be careful on how I say this, but for most human beings, that's just going to be a slap on the wrist. Go home, think about what you did. But it is still an offense. Let's talk about renewals now. Let's talk about renewals. Very easy in the state of Colorado. Every 5 years, you're going to have to renew your permit. Now, the law says, and this is where a lot of people kind of mess up. I get a lot of people who are like, I got to start all over because I didn't read this. The law says that they want you to start within 120 days prior to the expiration of the permit. So they want you to start applying 4 months before it expires, within that time frame. Honestly, the closer you are to 120 days, the better off you will be, because they do have that much time to kind of go through the process to renew your permit. So 120 days prior to the expiration of the permit, they want you to start renewing that process. They can charge you up to $50 for their own county fee. And then currently the state fee is $13. So potentially up to $63 to renew that. And again, every 5 years. Now, there's a lot of confusion with sheriff's office. Again, this is why it's important for you guys to understand this stuff about the training requirements every 10 years. So every 10 years, the certificate that we give you is valid for 10 years. You have 10 years from today's date. If we read the requirements for a renewal, this talks about 1812-203-18 to 1G. If we go back to it, which we might hear in a little bit, having a training certificate is actually 1H. If we follow the strict rule of the law, you actually do not have to take a class every 10 years. You only have to take it once. If you're only training once every 10 years or every 20 years or every 30, you're batshit crazy, and I don't know what the hell you're doing with the handgun, to be honest with you. I'm not going to tell the government to take it away from you or anything like that, but I'm going to stay away from your ass if you're only taking one class for a lifetime. But realistically speaking, if we follow the letter of the law, you only have to take one class, and as long as you continue renewing every 5 years without any lapse, never again do you have to take another class.
So basically to say, renewal does not technically require a current training certificate.
Correct. Yeah.
New applications do.
Correct. Yeah. Anything you want to add to?
And just to clarify what I just said, current training certificate means a certificate issued within the last 10 years.
10 years.
So if you guys take this class, you get your certificate, you wait 9 years and 364 days, and then go apply, that certificate is still valid for your initial application. When you renew, if your permit is still valid, when you renew, each time you renew, technically you do not need a new training certificate.
And one thing is, if your permit expires, it's expired, by the way. But once your permit expires, they do give you a 6-month grace period. They do give you a 6-month grace period, and that's here under 2. If you do not apply or renew, within that 6-month grace period, you wait 6 months and 1 day, then it's a new process. You're now a new application, no longer a renewal. No longer a renewal. All right, folks. Let's talk about where you cannot carry. So 1812 exceptions, it really doesn't apply to any of us. 1812, 213. In fact, I think 212, very brief there. But 213 reciprocity, best place for you to find the list of reciprocal states is at the Colorado Bureau of Investigation's website. Go to their website, the Colorado Bureau of Investigation, CBI website. And there, under firearms and reciprocity, you'll find the list of the 33 states where you can carry. There's a lot, I see online a lot of people advertising, oh, get a multi-state permit. There's really no multi-state permit. Every state has their own permit process. And really every state except like maybe Illinois or California has reciprocity with a lot of states. But I do want to talk about 1812-214, which talks about where you cannot carry in the state of Colorado, where you cannot carry in the state of Colorado. Also, it talks about the authority that you're granted, and this should go without saying, but you're nobody special just because you get a concealed handgun permit. I know your mom tells you you're super duper special, but that little piece of plastic doesn't give you any arresting powers or any superhero powers or anything like that. If anything, it gives you a personal responsibility to train, and then train again, and then again, and then again. So very important that you don't have any special privileges just because you have this stupid little piece of plastic that says you can now cover up your gun. So anything you want to add before?
Nope.
No? So 1812, subsection 2, 3, and 4 are where you cannot carry in the state of Colorado. Subsection 2 talks about you may not be able to carry where it is prohibited by federal law. And that's basically just federal property. If we really break it down, it's federal property. Post office, Social Security Administration building, the VA hospital, that type of stuff. So if it is actual federal property, you cannot carry your gun there. We'll give you exceptions here in a little bit. One thing that I have to kind of clarify here is the airport is owned by the city and county of Denver. DIA anyways. Springs Airport is owned by Colorado Springs. So it's not owned by the federal government. We can cover that here in a little bit, but it's important for me to clarify. Banks are not owned by the federal government. Schools are not owned by the federal government. So it's important for you to understand to differentiate between federal property and what you think federal property might be.
So in Colorado Springs, we have a bunch of military bases. We have a few up in the Denver area. You cannot conceal carry with this permit on those
Correct.
federal pieces of property. Also, the post office parking lot does count as the federal property. Didn't used to always be that way, but a district court decision extended that line out to the parking lot. You cannot have a firearm in the parking lot of the post office. That's a felony.
And the way they changed that was some fool found out.
Yeah, some guy found out the hard way.
The hard way.
Yeah, so also if you go to the Federal Center in Denver and Lakewood, places like that, federal property, be careful. 2
exceptions to that. Really more, but 2 main ones, national forests, national parks. You can carry at national forests, national parks. You just follow state law. This is something that was passed in 2009, came into effect February 22nd of 2010. And the reason why you follow state law is because there's no federal guideline on open carry or carrying concealed, but there are state laws on how to open carry or carry concealed. So if you're at the Grand Canyon, you're going to follow Arizona state law. If you're on the Arizona side of it, of course. If you're at Rocky Mountain National Park or Pikes Peak here in the state of Colorado, then you're going to follow Colorado state law, whatever that law may be, stuff that we're already talking about right now in regards to open carry, carrying concealed, that type of stuff. So you can carry on to national forests, national parks. You just follow state law. Now, I still would advise that you go to their website. If you're going to go to Yellowstone or whatever it might be, go to their website because there might be something on the federal side that kind of restricts you from go into certain places like information centers or bathrooms or play areas that are being maintained and that type of stuff. So always encourage you to go to their websites and get the proper information there. But in general, national forests, national parks, you just follow state law when it comes to how to carry, whether it be open carry, carry concealed, or in your vehicle, that type of stuff. Anything you want to?
Nope.
So subsection 3, you may not carry on the real property or into any improvement erected thereon of a public elementary, middle, junior high, or high school. Can't carry on to public schools K through 12. Please understand that says public schools K through 12. Charter schools are also public schools. Charter schools are also public schools. But there is an exception. Subsection 3, paragraph A says that a permittee, notice that it says a permittee. It doesn't just say a person. It says a permittee may have a handgun on the real property of the public school, so long as the handgun remains in your vehicle. And if you're not in the vehicle, the handgun is in a compartment within the vehicle and the vehicle is locked. So to give you an example, you go to the public school K through 12, you're dropping off your mistakes. And you're not going to get out of the car. You can have your gun on you, lock, loaded, ready to pew pew. If you have your permit, remember it says permittee up there. You have your permit on you. If you're going to get out of the car while on the parking lot of the public school, before you get out, put your gun in a center console, glove compartment, something similar to that. Get out, lock the car, and then you're good to go. So there is another provision for anybody who works for a district. Honestly, this could apply to just about anyone, but if Isaac is hanging out his kid's school Monday through Friday from open to close, I mean, at some point he just looked like a fucking weirdo. More so than he already
more than right now.
More than right now. I do know a lot of helicopter parents who they insist on going to their kids' school like every single day. Could potentially apply to them, but generally speaking, this is for faculty, people who actually work there and have a reason to be there Monday through Friday type stuff. And that's 3B. A permittee who's employed or retained by contract by a school district as a school security officer may carry a concealed handgun onto the real property or into any improvement erected thereon of the public elementary, middle, junior high, or high school while the permittee is on duty. You do have to be on duty while you're carrying the gun there. That's important for me to mention because I know a lot of people, I'm sure you as well, a lot of people who attend church at a school. They rent the auditorium from a school, and it might be a teacher that works Monday through Friday at the school, but while they're attending church, they're no longer on duty unless they get that special provision from their district saying that they are on duty even when they go to church. So it's these little details that very important for you to know.
Nope.
Sweet. Final circumstance where you cannot carry in the state of Colorado. Final circumstance where you may not carry is basically at any building, whether it be government or private, that has security guard and electronic weapon screening devices permanently placed at each entrance to the building. Security personnel electronically screen each person who enters the building to determine whether the person is carrying a weapon of any kind. And security personnel requires each person who is carrying a weapon of any kind to leave the weapon in the possession of security personnel while the person's in the building. Now, usually I don't get too complex with this stuff because like Pepsi Center is a private establishment. If I go to the Pepsi Center and I have my firearm on me and I'm like, I forgot, you need to have a place for me to leave the gun with you. And Pepsi Center is like, no, we're not going to do that. Well, they're a private organization. I'm not going to sit there and argue with the Pepsi Center. I don't think there's anything in Pepsi Center that's that dire for me to sit there and argue with somebody. So that's why for me personally, it's not important whether they have a place for them to store my firearm or not. But if we look at what the law says, they do require each person who's carrying a weapon of any kind to leave it in the possession of a security guard. I don't know if I'd feel comfortable with that, but that is what the law is. Now, this is anything that's private or government. You go to the DMV, Department of Motor Vehicles, no security guards, no metal detectors. So you can go get your driver's license with your gun on you, lock, loaded, ready to pew pew. Any state agency from a state level down, any government, from a state level down, according to the law, they can take away your open carry privilege, but they cannot take away your concealed carry privilege. Open carry, if you want to talk about that in person, we'll talk about that in person. In the interest of time, we're just not going to talk about that. But they can take away your open carry privilege, but on their own, they cannot take away your concealed carry privilege. So if the DMV didn't want you to carry a firearm there at all, by law, they would have to implement security guard and metal detectors. I say metal detectors, but the law says electronic weapon screening devices. But metal detectors and security guards at every single one of their public entrances. That's the only way they can take that away.
Yep, that's good.
Signs. Signs don't mean anything at private establishment. In the state of Colorado, there's actually only one sign that has any legal weight in this context. And that's the sign at government facilities or areas that says no open carry. Remember, they can take away open carry, but not concealed carry, not on their own. So if you go to public libraries, I know in Pueblo, when we do classes in Pueblo, their public libraries has a sign that says no open carry. And if you are carrying, you have to have a permit according to the law. That's the only sign that means anything. You go to Whole Foods, and they have a sign that says no guns. Legally, that sign at Whole Foods means absolutely nothing. It doesn't carry any legal weight. If we read 5, though, it says, nothing in this part 2 shall be construed to limit, restrict, or prohibit in any manner the existing rights of private property owners, private tenants, private employers, or private business entities. So if you go to Whole Foods, you're like, I'm going to disregard that sign. You're a gun-toting hippie, which we need more of you guys, by the way. We need a shit ton more gun-toting hippies on our side. You go in there with your gun. You reach out for your non-GMO, cage-free tofu. You reach out for that weird shit. And your shirt rides up, and an employee of that establishment sees your firearm, and they request that you leave. Got to leave. The sign means absolutely nothing. With or without a sign, if they ask you to leave for whatever reason, for that matter, for whatever reason short of a civil rights violation, you got to leave. Same thing if you're employed there. If you work there, if you're shopping there, you can be kicked out or fired for whatever reason short of a civil rights violation.
The way I like to explain this to people is whatever signs you see on the window when you walk into Starbucks are informing you of what the store policy is. They're not informing you of state law. And that is different from other states. There are signs in other states that do matter. They do make a difference. But in Colorado, the little Ghostbuster sign or even a big placard on the window that says no guns allowed, no concealed carry allowed, blah, 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 blah. For private businesses, that is informing you of their policy. That is not a law. Walking into that store with a gun is not a violation of the law. It's a violation of the policy. And the store can choose to enforce that policy if they want to, or if they don't know about the gun, there is no policy. There will be no enforcement of that policy. But once they have a reason, whatever that reason is to kick you out, if they ask you to leave and you don't leave, you are now trespassing.
6 right here. A lot of people have told me, there's another section that talks about these signs and stuff like that. 6 talks about this provision of this section applies to temporary emergency permits issued to pursuant to section 1812-209, and it ends there. We'll talk about case law in the annotations, but the only case law here is the students that won their right to carry at college campuses against the CU regions. So, yeah, read that stuff. Anything else you want to?
Just to mention case law, sometimes this law, because one of the things about Colorado law that I like is it's brief, even though you've been sitting here a while, it may not seem brief compared to a lot of other states. This is very brief, but in brevity, a lot of gray areas are left out, and those gray areas may be covered by case law. And so if you're really curious and you want to know background information or how the law has actually been applied, case law is always referenced at the bottom of that section that applies to that section.
Yeah. And we'll give you some examples here when we talk about the self-defense stuff. But that's pretty much it. I mean, not a whole lot to it, but still very, very important stuff. I've had people tell me, why would you spend an hour and a half talking about the laws? Really, I wish I could spend 3 hours talking about the laws, because there is a lot of that confusion and stuff like that. That's why it's important for you to rewatch this video, go to these sections, read them 3-4 times, because it might take that time to kind of analyze and organize everything inside your brain, depending on how you learn. But that is part 2. All right, so now we're going to talk about self-defense. Generally speaking, self-defense is broken up into 2 categories. It's outside of your house and inside your house. We're going to cover 18.1.704 first, which is outside of your house. And when I say outside of your house, I mean quite literally outside of your house. And I'm using that word literally as Webster would define it, not as a Valley Girl would define it. So I'm using that word literally. Your front yard, your backyard, detached structures on your property, your entire property itself. Again, we'll talk about inside your house a little bit later. So anytime you would be outside your house, this is the law that you would follow. That includes your vehicle when you're driving it. Your car is not an extension of your home. Your place of business doesn't have the Make My Day law in the state of Colorado. So let's look at this law, 18.1.704. The actual name of it is use of physical force in defense of a person. I've got to point this out really quick because a lot of gun owners misunderstand what a person means. A car, not a person. Bicycle, not a person. I don't care how much clothing your dog has. If you do your dog's nails and you call it fur babies, not a person. Right now we are talking about actual human beings, actual people here. So when it comes to deadly physical force outside your house, we're not talking about physical force. That's a separate issue. I want to focus this on guns. You would read subsection 2, 18.1.704, subsection 2, which says deadly physical force may be used only if a person reasonably believes that a lesser degree of force is inadequate and the actor has reasonable grounds to believe and does believe that he or another person is in imminent danger of being killed or receiving great bodily injury, or the other person is using or reasonably appears about to use physical force against an occupant of a dwelling or business establishment while committing or attempting to commit burglary, as defined in section 18.4.202 to 18.4.204, or the other person is committing or reasonably appears to about to commit kidnapping as defined in section 18.3.301 or 18.3.302, robbery as defined in section 18.4.301 or 18.4.302, sexual assault as set forth in section 18.3.402 or in section 18.3.403 as it existed prior to July 1st, 2000, or assault as defined in section 18.3.202 and 18.3.203. Now, I always oversimplify this by saying 4 general categories: threat of death, serious bodily injury, kidnap, sexual assault. The reason I like to oversimplify it, but I have to stress this, it is an oversimplification. The only reason I like to do that, if you read all of these definitions, robbery as defined in section 18.4.301 or 18.4.302, that's somebody taking your stuff while intimidating you or physically attacking you. So if somebody's trying to steal my holster while kicking my ass all at the same time, it's not the fact that they were stealing my holster, it's the added element of them using physical force against me to steal that holster. So for me, that all falls under threat of death, serious bodily injury, kidnap, or sexual assault. So that's why I like to kind of clump it down to those 4 general categories. But please, do yourself the favor and read it. Also understand, one of those 4, as I would state it, as I would oversimplify it, threat of death, serious bodily injury, kidnap, sexual assault, there's one of those 4 in play, not all of them, just one of those 4, and you feel like a lesser degree of force is inadequate. So you feel like you have a reasonable belief that there is no other option but to use your firearm. That's when you can use deadly force outside of your house.
I want to stress again, one of the reasons why we oversimplify this is to stress the protection of life and limb and not stress the protection of property because and this is our opinion, obviously the laws do lay out the robbery situation, but our focus is protection of life and limb. our focus is not the protection of property. And that is our own personal opinion about that, but we believe very strongly that there's not anything physical, physical belongings that is worth your life or somebody else's life. If you feel differently, that's really on you. But in order to make this something that is easy to digest and stresses what we think is important, that's why we focus on those 4 things. And ultimately, if you really boil down what this is saying, those 4 things really are the foundation of what this is saying.
Yeah, no matter what you try, I get a lot of people who are like, well, B says attempting to commit burglary. Yeah, but if you read what burglary is, there's an assault element to it. There is a physical attack element to it. It's not just stealing your stuff.
And there's a physical assault and attack element under the definition of the law,
Correct.
not under what your interpretation of what burglary is.
Correct. Yeah, and this is one of these sections where I really want to show you the importance of reading case law, because although I did just tell you that you basically have to have a reasonable belief that your firearm is the only thing that could have handled that situation. If you read the law, a lot of people interpret that as saying you have to find a way out first. If you read case law, it doesn't say this in the actual law, but if we come down and if we read this section of the case notes, it says the defendant, if he did not provoke the assault, is not obligated to retreat or flee to save his life, but may stand his ground. Now, this doesn't mean we have a stand your ground law in the state of Colorado. That's just what they're saying for the purposes of this section. You don't have to try and flee, but you definitely have to make sure that the handgun was the last resort. In other words, I can essentially, if I wanted to be stupid, if I wanted to be silly, if somebody was talking shit to me across the street and they were approaching me and wanted to fist fight me, I don't have to try and find that way out. I can sit there and fight this individual. I'm not going to. I'll probably run away or whatever because I'm a little bitch. But I'm not going to put myself in that circumstance. But if we just read what the law says, I don't have to try and retreat. I don't have to try and flee. I can sit there and use my fist. Now, if it gets to the point where they get stabby or I feel like my fists are not good enough, this is why it's so important to not just read the law, actually train. Because it's one thing what the law says and what you should do and could do are 2 different things. So, but very important to read the case notes. Anything else?
Nope.
No. So now let's go inside your house. Let's go inside your house. Probably one of the very few times when people would gladly accept Mexicans inside their house.
Ooh.
Woo.
So we're going to 18.1704.5.
A lot of people are like, no, they mow my lawn all the time. Yes, my cousins do. 18.1704.5. This is the famous Make My Day Law, the famous Make My Day Law. One thing that I'd like to start by pointing out is the fact that it says, the General Assembly hereby recognizes that the citizens of Colorado have a right to expect absolute safety within their own homes. So you as a citizen of the state of Colorado have a right to expect safety in its totality, in its wholeness, in its completeness, not just a little bit, not just from noon to 5, but 100%. 100% you have the right to expect absolute safety, absolute safety. I'm going to paraphrase here, but please read the law for yourself. Somebody comes into your home uninvited. The law, I'm sorry, let me read this as the law would say, in your dwelling. Uninvited, and they have the intent to commit a crime or they are committing a crime. In addition to the uninvited entry, you have the right to use any physical force, including deadly physical force. Again, that's in defense of yourself, any other occupant of that dwelling or property within that dwelling. So we go back to these objects that I talked about in the other law. Your dog, for instance, that you dress up and you call fur baby and all that stuff. Now you can John Wick them. Now this is a time when you can. I don't recommend it. I have a dog and I kind of like the dog and all that stuff, but stuff to think about. Just because we mention something doesn't mean it's something we encourage. But if we're being objective and for the purposes of being factual, if somebody comes inside your house to steal your dog, I call it a rescue mission if you're dressing up your dog. Uh, you may not see it that way. I see it as a rescue mission. But now you can use deadly physical force to defend that dog because it's inside your house. It's inside your house.
So I want to add a couple of things. Where it says when the occupant reasonably believes that such other person, that's the bad guy, might use any physical force, and this is a quote, no matter how slight, against any occupant. So that is a very low threshold. So you need three things. You need unlawful or unwelcome entry. You need a reason to believe a crime is being committed or about to be committed. And you have reason to fear for your safety, no matter how slight. I like to set this up. I learned this from Edgar, but I set up my own situation where let's just talk real quick about a hypothetical, which is I hear a bump in the night. I get up, I grab my gun, I go downstairs. I see a guy sitting on my couch, eating my Cheetos, drinking one of my Cokes, putting it on the coffee table with no coaster. Can I shoot him? So I have unlawful entry. I have a reason to believe a crime is being committed or about to be committed. I have petty theft and destruction of property and loitering. And the third one, any reason to fear for your safety.
And here's where again, case law comes into effect. And again, one thing you got to understand, we're just giving examples just to kind of give you an idea. So the intent to use physical force against you, harm you in any way, shape, or form, right here it says to be immune from prosecution under this section, the defendant must establish by purportance of evidence. I heard that means a lot. By purportance of the evidence that he or she had reasonable belief that the intruder was committing or intended to commit a crime against a person or property in addition to the uninvited entry. Here's where the important part is, and this is in case notes. It's not in the actual law up top, this is in case notes. This inquiry focuses on the reasonable belief of the occupant, not the actual conduct of the intruder. So that gives you as a homeowner kind of an extra protection there. They're going to look at this based off of what you say. And for me personally, because it is based off of what I say, I think I have even more of a responsibility to be a moral human being. And again, not get caught up in, oh, well, I can shoot you for my Altoids. I can shoot you for a TV. But I have this much responsibility with this firearm to make the right decisions instead of making emotional, irrational decisions. But in the interest of being factual, that's what they would look at.
So in the example that I provided, where you have all the legal definitions met, and then I ask, can you use deadly force? Yes, I could use deadly force. Then I ask, should you use deadly force? And the answer to that question is, I do not have enough information in that scenario you provided for me to answer that question. There is no way for me to describe every single scenario where you may have to make that life or death decision. But you need a set of skills and a set of principles that you're going to abide by before that happens. You need to know what you can do under the law. You need to know what you can do with your tools and your weapons. And you need to know what you're prepared to do. And if you haven't done that yet, and this event happens, you're going to be caught by surprise, and you're going to make probably a decision that is not going to be the best decision. So that's why it's important to think about this stuff as a whole picture and not just say, well, when can I shoot him? That's not the right question. Right. The right question is, what are you prepared to do? And what is the best decision based on what your values are? If I have kids if the bad guy's between me and my kids, it's game on. If there's a bad guy downstairs and all my kids and all my family are safe, I'm gonna let the dog handle it. Correct. Okay? Or I'm gonna let the police handle it. But that's my own personal set of decisions and principles, but they are based on what I can do and what I know I'm allowed to do and what I'm prepared to do.
And I think that's an important conversation. I don't think that this conversation gets had a lot. I used to get asked this question. I still get asked this question. I respond to it differently now than when I first started doing these classes. Because, you get better at teaching and instructing and deciphering information. And people would ask me this stuff. Okay, like, what if this happens? And what if the bad guy comes in and they're looking at your TV and you're just not sure? The reality is that I can't tell you what to do. Isaac can't tell you what to do. There's no instructor out there. Sometimes we as human beings want other people to tell us what to do. I think kind of to have a way out. you're going to have to make that decision, and you're just going to have to live with it. And this is why training is so absolutely crucial. Get good training. In my opinion, if you're going to an instructor who's constantly fixated on killing people and making sure they die, we say a lot of stupid stuff. I just talked about John Wicking somebody about a dog because it's funny. It lines up the mood. It's kind of weird to be here talking to each other, talking to a camera. It's nice to have fun, and you guys break up that monotony and say some silly shit every once in a while. But in reality, it's you. It's going to be you and the bad guy. And depending on how religious you are, your deity of choice. So you have to understand this is a decision you have to make, and you're going to have to live with it. You're just going to have to live with it. This is why training is so absolutely crucial. One thing that I do want to talk about in subsection 3 and 4, I'll bore you from the other stuff. It says, shall be immune from criminal prosecution for the use of such force. If you do everything in accordance to this law, you shall be immune from criminal prosecution for the use of such force. If you do everything in accordance to this law, you follow this law, you don't do anything completely stupid, irrational, you are immune from civil liability for injuries or death resulting from the use of such force. Can't be sued civilly, cannot be charged criminally in a legitimate make my day law situation. I got to preface that by saying legitimate make my day law situation, because although not very common that I know of in Colorado, but there have been cases where it wasn't the case. One of them being down in Pueblo, an individual rescinded an invite, and this is what was the headline. He rescinded the invite, and it ended up shooting. So the headline made it seem like they were an intruder, somebody they invited in, kind of like a contractor or something, and then they asked to leave, and then they ended up being charged. So in my head, I'm like, well, no, that doesn't make sense, because you can rescind an invite from somebody you don't know. But you read the article, they were invited into the house to live. So that changes everything. They were no longer a complete stranger who was coming into your house to fix your carpet or fix your plumbing. This was somebody you invited in to live in your house. They became an occupant of that house. That house is now theirs as well, and you have to go through the eviction process to go through that. If it was a plumber that you were inviting in and you don't feel comfortable and you ask them to leave, then you can resend. If they refuse to leave, you're back to the make my day law. Continuing on with that trail, if you've ever had a personal relationship with this individual, no longer make my day law unless you get a restraining order against that individual. One thing they found out really quickly is that a lot of people were trying to use the make my day law to essentially justify their murder of somebody they slept with, or friends or roommates or that type of stuff. So if you've ever had a personal relationship with that individual, a restraining order, and this is important. This is why it's so crucial to read the case laws, case notes, and all that stuff.
Yeah, because nothing he just said is actually here in the statute. It's all in the case law. So that's why you have to know that stuff, because if you went strictly off of this, you might be setting yourself up for criminal prosecution in certain circumstances.
Yeah.
So and just to note on the civil part, you're immune from civil action inside your dwelling. Outside your dwelling, there is no statutory protection from civil litigation, even if you were criminally cleared of any wrongdoing or legally justified in doing what you did. You could still be sued by the bad guy or the bad guy's family.
And we kind of already covered this, but I gotta kind of reemphasize this because this comes up a lot. Fear of being sued should not be a justification of you killing somebody. I don't shoot to kill. I don't shoot to injure. I shoot to stop a threat. Inside my house, I'm not worried about the TV and stuff like that. That's not why I carry a gun. Guns are not about killing people. Guns are about keeping people alive. I hear a lot of people say, "Oh, well, they're going to sue you." Let's be honest. A lot of us that I know, for us, it's probably true. But if you, as a student, take it wrong or however you want to take it, chances are you're watching this video because you clicked on free. You've seen a free concealed carry class. I'm gonna go out on a limb here and say you ain't got that much shit to kind of sue for. And I say that in the most kidding and respectful way I can possibly say it. But most human beings really don't have that much to really care about. O.J. Simpson still owes millions of dollars to the Goldstein family. Um, they're probably never going to get the full amounts. They're probably never going to get that stuff. Suing somebody doesn't mean you're guaranteed to the money you're suing them for. So if you're worried about lawsuits, you're carrying a gun for all of the wrong reasons. I don't carry a gun because I'm afraid somebody's going to sue me. This stuff is a freedom tool for me, and it's a self-defense tool. Beyond that, if it's not affecting my freedom, if it's not endangering my well-being or that of my family or people around me, then no reason for that gun to come out.
So under some of the definitions of deadly force, you could find yourself in trouble just for threatening to use deadly force against somebody unless you're legally justified to do so. So let's take for granted that one of these situations has been met, such as threat of sexual assault or something under the Make My Day law. I can threaten to use deadly force legally in that situation. I can say, get out of my house or I will kill you, or I will shoot you, or I have a gun and I will use it, things like that. Those are threats of force, and you can do that if you're legally justified to use that force. But if you're not legally justified to use the force that you're threatening to use, you could find yourself in legal trouble. If you get into an argument over a parking spot at Walmart and you say, I have a gun in my car, you could be put in jail for doing something like that. So threatening to use deadly force is something that you need to be aware of as well.
Yeah, notwithstanding this provision of subsection 1 of the section, a person is not justifying using physical force if, with the intent to cause bodily injury or death to another person, he provokes the use of unlawful physical force by that other person, or he is the initial aggressor, except that his use of physical force upon the other person under the circumstances is justifiable if he withdraws from the encounter. So very important for you to read that. Earlier we only talked about, it's important that you do read the entire thing. When we were talking about 18.1.704, we were only talking about the deadly force when legally you were justified to use deadly physical force. But there's a lot more to it. We didn't read subsection 1. We didn't read subsection 4. Very important for you to read that stuff.
Another thing about deadly force is, I'm only saying this because we do get this question from time to time. Is it okay for me to shoot them in the leg to scare them away? Is that considered deadly force? If drawing the gun and pointing it at somebody can be considered deadly force, then certainly shooting them anywhere on their body is going to be considered deadly force. You may shoot somebody in the leg either on purpose or by accident. Doesn't really matter. It is still deadly force. We can talk in the class if you have questions about tactics, about what the best place to shoot, blah, 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 blah. But there is no scenario where you can shoot somebody in the foot and say, well, I didn't mean to kill them. I was just trying to slow them down. That doesn't work. You are using deadly force against somebody if you, under these definitions, threaten or utilize a dangerous and deadly weapon against another person. Yeah. Don't shoot people in the leg.
The arm.
or maybe the arm. So a lot of this stuff is theoretical until you start applying it to actual situations. Yeah. That's where case law starts to really make this stuff make sense. One of the questions we get in our classes all the time, there's always somebody who asks this question. It's usually an old white guy who asks this question. If I shoot them and they end up on the front lawn, should I drag them back in the house? Yeah. No. The threshold and the use of deadly force is where it took place, not what happened to the person afterwards. So if they were in your dwelling and you used deadly force against them and they made it outside and died on your front lawn, it doesn't matter what happened to them. It matters where the initial act happened. So not only that, but dragging a dead person off your lawn into your house is a crime. It's tampering with evidence and tampering with a body, all of that stuff. Like, that's a separate issue, but don't do that. Yeah. If somebody makes it down the street into the hospital and dies in the hospital, that's none of your concern. Your concern is where that initial action took place.
Yeah. And with that, we have to understand that if you were an individual that probably grew up around guns, you probably got told a lot of this weird stuff. If they fall outside, drag them back inside, and shoot somebody so you don't get sued, because dead man tell no tales, that type of stuff. we also have to understand where you got that information from, and that's usually information that gets regurgitated just for the sake of being regurgitated. Again, it's kind of back to the stopping power thing. Nobody knows what it really means, and when you tell them what it means, they're like, "Oh, okay," like it changes things. It is our responsibility to stop that misinformation and stop these cliches that are going about realistically. Because we do, I hear it as well in classes. It just gets repeated and repeated. Nobody knows why you repeat it. Nobody knows why we say this stuff until we understand. Oh, great grandpa told grandpa, and then grandpa told dad, and then dad told me. So I just continue to repeat this stuff. But just because you repeat it doesn't make it correct. Just because your parents told you, I hate to say this at the risk of my kids watching this, but just because your parents say something, it doesn't make it right. It's our responsibility to correct everything that is incorrect in these trainings and the spreading of knowledge. So now that we covered the laws, we covered about choosing guns, we talked a little bit about choosing holsters, we talked about safety. Uh, I think we would be irresponsible if we didn't take the opportunity to talk about mental health and how important it is for you to take care of yourself mentally, especially nowadays. I hate to say it, it sounds like a cliche. I remember when we used to say, "Oh, times are crazy now," and then you look at what's really going on right now. Like we had no idea how crazy it could actually get. Being shut down, being home, not going outside, or being very limited in social interactions and just your everyday just well-being. I know I hear a lot more about depression going on now, even more so than before, which it was already increasing. So if you're brand new to firearms, I think it's important for you to think about that mental health. That it's okay to kind of reach out to somebody. It's okay to talk to people about this stuff. It's okay to call up a friend and say, "Hey, I need a day or two away from the guns," or whatever the case may be. Have that support system around you. It's this weird dynamic of being a gun owner but still struggling with that mental health. We're not an organization that feels that that's incorrect. I think everybody has the right to self-defense, even people who suffer from depression or anxiety, or because mental health is a wide spectrum of things. It's just not what we commonly call mental health. It's a lot of stuff: anxiety, stress, PTSD, that type of stuff. So there's an organization that we work with. I'll increase that. We'll probably edit this to make this a little bit larger, but it's Walk the Talk America. Walk the Talk America. This was founded by Mike Sedini. Their website is WTTA.org, WTTA.org, or even walkthetalkamerica.org. Visit them. They have free confidential screenings. These screenings, I kind of played with it a little bit just to kind of understand what they did. And it's very basic. It's nothing too complicated. It doesn't ask you for personal information or anything like that. It just it asks you a few questions and you answer the questions, and it kind of guides you on what what things you may have going on, so you can get the proper help. So anyways, Walk the Talk America, WTTA.org. Fantastic organization if you're a gun owner but also happen to have some mental health concerns that you want to talk about. They have fantastic resources. Here in the state of Colorado, if you want something a little bit more immediate, something a little bit more, let's hurry up and I need to talk to somebody right now. The Colorado Crisis Center is also an organization that works with, it's more of a suicide prevention. As opposed to Walk the Talk, it encompasses all mental health concerns, again, whether it be anxiety or whatever the case may be, also suicide and suicide prevention. But Colorado Crisis Center is kind of a little bit more direct to if you need to talk to somebody immediately. You can always reach out to us. The unfortunate thing about that is, as available as we want to be, if you need something immediate, I need to talk to somebody right now. Unfortunately, I hate to say it, but I can't be there 24/7. Colorado Crisis Center can be there for you 24/7. They're available 24/7 if you need to talk to us. If it's not an urgent thing, Isaac, myself, Mike Sedini, Walk the Talk America, you can always reach out to us and we can guide you to it. I'm not a therapist. I don't know you to be a therapist either.
Only in my own mind.
Yeah. So we're not therapists. We can't fix your problems. To be honest with you, I don't think anybody can, but it's always nice to talk to somebody. But we can definitely guide you and get you to the proper people that are experienced and have the knowledge on how to deal with that stuff, or even just know how to properly listen instead of somebody who's giving you opinions about stuff that you may not want to hear. So Walk the Talk America, check them out. They are on Instagram. They are
Walk the Talk US.
Oh yeah, Walk the Talk US on Instagram. They're also on Facebook and Twitter. So check them out, Walk the Talk America.
So real quick, just to add to that, the reason they're called Walk the Talk America is because the gun industry in general has done a great job of blaming mental health for things like mass shootings and the high rates of suicide. And Mike Sodini decided to initiate a program for gun owners and gun industry people to take responsibility for that. Like it or not, we all are responsible for each other's actions. That I know a lot of people don't believe that, but that is how it works. That's how it plays out. And so instead of blaming other people for the issues facing the gun industry, this is an organization that's trying to take responsibility and trying to actually get things done. The founder of Walk the Talk America loves people, loves mental health, and loves guns all equally. So this is not some kind of weird conspiracy to get gun owners to give up their personal agency or anything, that their ability to take care of themselves.
Quite the opposite, if I may interject. Quite the opposite. They're trying to fix Walk the Talk. I know Mike Sedini is actively trying to fix on the mental health side of it with counselors and therapists on how they approach gun owners so that they understand what we as gun owners can be affected by, because we don't want to hear a therapist talking about getting rid of guns and supporting that type of legislation. So they are actively working them alongside Zephyr Wellness out of Nevada. They are working to kind of change how therapists approach gun owners who happen to have some mental health issues. So quite the opposite on this conspiracy of taking guns away and all that stuff.
So even if this is not an issue for you, there is a possibility that you would know somebody. So please take the opportunity to spread the word as well. You know, people you think may not be affected by this, it turns out they are. There was a well-known writer in the gun industry who killed himself a few years ago. It was a great shock to everybody. Nobody could believe it happened. This guy was a longtime Second Amendment proponent, and it was just a big tragedy. There are people all the time in this community who need this help. So please be an advocate. If it doesn't affect you directly, still please be an advocate for people. Okay, so we're going to talk about what to expect when you come into the class. Hopefully you made it through the video this far. The class itself is not going to look the exact same for everybody. Edgar does his class different than I do my class, and we're going to talk about different things depending on questions. Please be prepared to bring any questions you have to the class. If it was a question that's already answered in the video, try to go back and check the video and see if you can get your answer there. But if you can't, please bring those questions to the classroom. The plan is to go over some basic gun handling skills in the classroom, answer questions, run through the safety again one more time, and that is where you get your certificate. You cannot get your certificate if you do not come into the class. And in this email that you got with this video in there, there's details about when you should show up and how to conduct all that stuff. We cannot guarantee 100% that you'll be able to social distance perfectly, but you are welcome to wear a mask in the classroom. They're not required. Not everybody's going to be wearing masks, but you are more than welcome to wear one if you like to. And
I got to note that you might be sitting there like, well, that's not required. That's us. I'm not a doctor. He's not a doctor. If you show up without a mask, I'm not going to question you and grill you about your medical history or why you're not wearing a mask and that type of stuff. So we all assume our risks. We're doing this, again, not because we prefer to do it this way, but because we feel like it's the responsible way to do it to keep you safe and keep other people safe. But at the same time, you have to assume your own risks just the way we're assuming our own risks as well.
So one more thing, we want to talk about donations. This is how we keep going. Yes, this is a free class. There are no strings attached. If you walk out of this classroom or walk into the classroom not expecting to drop a dime, you can walk out of the classroom with your certificate in your hand. No tricks, no hard feelings. However, we cannot survive without donations. We have done this for almost a decade, almost 50,000 students. I think by the end of the year, it will be 50,000 students that
Probably
we've,
over,
over 50,000. 100% supported by donations from students. We do this class because we know that some people can't afford to do that. If you can't afford it, if we're going to take your last dollar, I don't want your last dollar. Absolutely not. But if you can afford to donate, we need it. We need your money to stay open. We need your money to be able to offer these classes. We need your money to keep the lights on. I mean, there's a number of things that we need to pay for to keep these classes going, and we can't do it without your help. We don't get money from the NRA. We don't get money from anybody else. It's all been 100% from the students. I always tell the students, if you donate to our class, you get to take credit for our work.
Correct.
You can even tell everybody on Facebook it was your idea. I don't care. If you support the work we're doing, you get to take credit for it. And that's a big deal because you get to partake in the hard work that we've done. And it has been hard work. And we are proud of the work we've done. We enjoy this work, but we wouldn't be standing here without donations from the students. So there will be an opportunity to donate in the classroom when you come in for the class. And we'll probably cover this briefly again during the class. But yes, please consider donating to keep us operating.
If you work for an agency, a sheriff's office, and you're watching this video or you're going to attend the class to kind of see how our classes go, you should donate double for wasting my time and wasting taxpayers' time for something that is very, very easily fixed in 1812-202. And verified in 1812-201, you get to donate twice.
Thank you guys for watching this far. Appreciate it. Please keep this link because it may not be publicly available the whole time. So keep this link and have it handy in case you need to watch something again. Please, please, please at least watch the law section more than once. It's very important that you understand that stuff, and it is your responsibility, not ours.